will hear one case this morning. We are scheduled for 20 minutes of argument per side, but because it's only one case, I might be a little bit flexible on that timeline. The bottom line is that this is an important issue. We want to give it the time that it deserves, and most importantly, I want to make sure that the panel has the opportunity to ask whatever questions that they have. In preparation for today's argument, we have thoroughly reviewed the parties' briefs and the court record, along with a legal memorandum prepared by a research attorney. So we are very familiar with the facts as they are, and we encourage the parties to just dive right into their legal arguments. And with that, I'll call the case before us. It's case number 128896 from Saline and Reno counties, United Kansas Incorporated Appellants versus Scott Schwab Appellees. Would the parties please state their appearances?
Good morning, Your Honor. Ori Lev on behalf of plaintiffs' appellants.
Welcome.
Thank you.
Good morning, Your Honor. Bradley Schlossman on behalf of the appellees, and with me at council table is our Solicitor General, Anthony Powell.
Welcome. Would you like to reserve any time for rebuttal?
Yes, Your Honor. If I could reserve 3 minutes, please.
3 minutes are granted. And with that, you may begin.
Good morning, and may it please the court. Ori Lev on behalf of plaintiffs' appellants. Fusion voting, or allowing more than one party to nominate the same candidate for the same office, helps prevent the common problem of third-party votes being wasted or spoiler votes. Fusion was common across the United States, and particularly in Kansas, at the time of the adoption of the Kansas Constitution.
Counsel, I'd like to ask a very fundamental question, if I could. Are you on the wrong side of 10th Avenue right now? Shouldn't you be across the street in that domed building, asking for a change in the law, repeal the old one and bring in something new?
Your Honor, that's a fair question. And no, I think we're on the right side of the street, and I'll tell you why.
All right.
This is, first, of course, this court has the constitutional duty to render a statute unconstitutional if it is, just as the legislature would have the duty to repeal it. But the circumstances here are unique in that the dominant political parties have no incentive to change the laws that grant them an advantage and that stifle political competition in the state. So this is—
Isn't that a political problem, not a judicial problem?
Well, but it's also a judicial problem, Your Honor. I mean, the Supreme Court in Caroline Products, footnote 4, talks about this, says that, where there's a structural democratic issue that might prevent the normal legislative function from functioning properly, courts may need to adopt a heightened standard of scrutiny of the laws. But fundamentally, the challenge here, our challenge is that this law violates Kansans' rights to free speech and association under the Kansas Constitution, which was adopted at a time when fusion voting was widespread, commonplace. Constitution that has language that is substantially different from the U.S. Constitution's First Amendment, which this court just last year in the Hall case recognized is a strong indicator that the two constitutions should not be interpreted in lockstep where you have such differences in language. And that in light of that, the court should interpret the Kansas Constitution differently than the U.S. Supreme Court has interpreted the federal Constitution. So this is not a political question. It is a legal question that is appropriately before this court. Sure, the legislature could choose to repeal the law if it wanted to act against its own interests, but that does not negate this court's duty to consider the legality, the constitutionality of the statute under the state constitution.
So you see where our concern is. Is this as we say, a justiciable issue?
I don't, with respect, Your Honor, I don't see why it would be non-justiciable. And certainly even the U.S. Supreme Court and the other cases that have considered the constitutionality of fusion voting under state and federal constitutions have not held that the question is a non-justiciable one or a policy question. They have addressed the question on the merits and considered the burdens that the law imposes on parties and candidates and voters as weighed against the asserted state interests that purportedly are advanced by the anti-fusion bans. That's a traditional judicial function.
And now, I don't know the answer to this question. When there was fusion voting in Kansas, was the Constitution the same as it is now? The Kansas Constitution?
Yes, Your Honor. The Kansas Constitution was, I believe, adopted in 1859, and fusion voting was common then. At that time, parties printed their own ballots. There wasn't a state printed ballot, right? So different political parties would print their own ballot with their candidates, and multiple parties could have the same candidate listed for the same office. The problem with that system was that it led to fraud and corruption. Party ballots were printed in different colors. You could see who was being voted for by what color ballot was being dropped in the ballot box. You could have pay for voting issues and other problems with that system. That led to the adoption of what's known as the Australian ballot in 1891 in Kansas. The state took.
Counsel, the fact that previously fusion voting was permitted in Kansas doesn't tell anything about whether the legislature's decision in 1901 to limit that or to eliminate that practice was constitutional, does it?
Well, I think it does, Your Honor, as the Kansas Supreme Court has articulated. In ascertaining the meaning of a constitutional provision, courts consider the circumstances attending its adoption and what appears to have been the understanding of the people when they adopted it. And so I think the fact that fusion voting was commonplace and widespread both before and after adoption of the Australian ballot, right? There was a decade of the Australian ballot being in place with fusion voting.
So it was
commonplace.
permissible, but does that mean that it couldn't be regulated?
Well, I think that its permissibility shines a light on the meaning of the Kansas Constitution. The adopters of the Constitution in 1859 were familiar with fusion voting. And we submit that is an important reason this court should consider whether Articles 3 and 11 and the freedoms they grant Kansans incorporate the freedom of association and speech that are included within the practice of fusion voting. So I absolutely think it's relevant to the constitutional question. It's a reason that the US Constitution, which was adopted at a time when there were no political parties and there was no fusion voting, would reasonably be interpreted to not include this right, whereas the Kansas Constitution, adopted in a different time against a different historical background, which the court in Solomon told us is important in understanding what appears to have been the understanding of the people when they adopted the Constitution, I think is directly relevant. And I would also
Take
point.
a look at Section 3. I just would like to talk about that language.
Sure.
And in particular, we have this clause in Section 3 that is not in the United States Constitution, in the freedom of assembly provision in the First Amendment. And it talks about to consult for their common good, and talking about the people have a right to consult for their common good and to instruct their representatives. I found nothing to tell me what that means. Did you?
Well, Your Honor, other than the words themselves, I think that a political group of citizens organizing themselves as a political party to advance their understanding of what the common good is, the democratic process.
Is it an unfettered right?
Well, it's not an unfettered right. I think it does need to be weighed against state interests, but it's a fundamental right. And it's a right that even the US Supreme Court has recognized in numerous cases is a critical one. The importance of a party being able to nominate the candidate of its choice is fundamental.
Now, I think that the United States Supreme Court has said important. And of course, in the constitutional realm, we
apologize, Your Honor.
have these, even though fundamental and important might mean the same thing for most people, for constitutional scholars, they mean something different.
And I apologize, Your Honor, I misspoke. That is correct. But it is an important right. And to me, those words that are found in the Kansas Constitution, the right of the people to consult for their common good, are exactly the reason that this court should, against the historical background we spoke about, right? Those words adopted at a time fusion voting was a common practice. Exactly the reason this court should be open to interpreting that Constitution in a manner different than the U.S. Supreme Court interpreted the different language in the federal Constitution that does not contain those provisions.
Those words that you just used, quoting from section 3, are those words of limitation or are they memorial?
I'm sorry, I didn't hear the
Are
second.
they words of limitation of those rights, or are they words that memorialize a right?
I believe they are words that memorialize their right, Your Honor. I don't think,
Words of preservation, not limitation.
I do not believe they are words of limitation. I think they believe they are words that expand upon the right and describe it in broader sense than, for example, the U.S. Constitution.
So does
described
that-
right.
Does that indicate a way we should interpret them?
I think it indicates that the state constitution affords rights to association grounded in the language of assembly in a broader manner than the U.S. Supreme Court has interpreted narrower language in the U.S. Constitution. Not sure if that answers your question.
Yes.
But focusing on that, I mean, the fact that it may provide a different right, or it may color the right in a different way than the United States Constitution does that necessarily mean that that right is a fundamental right that is subject to strict scrutiny?
No, Your Honor, it doesn't necessarily mean that. But I think as this court struggles with the circumstances in which it should interpret the Kansas Constitution differently than the United States Supreme Court has interpreted the U.S. Constitution, the difference in language is a big red flag that says there's something different here. The difference in historical context in this case, I think, is important too, that says there's something different here. These rights were adopted with this broader language at a time when exercising this act of fusion voting was commonplace and assumed to be obvious. And if I may quote from the Kansas Supreme Court, another case, 1893, this is the Simpson decision. And it's a statutory decision. I'm not
Which
suggesting.
decision was it again?
It's Simpson.
Okay, thank you.
And it's a case involving whether under the Australian ballot law at the time, whether that allowed fusion voting. So it didn't address the constitutional question before this court, but I think the way the court described fusion voting in 1893, just a few decades removed from the adoption of the Kansas Constitution and use of the words, the right to assemble, to consult for the common good, is instructive of what those framers of that Constitution understood the right to mean. And the Kansas Supreme Court talked about, it said, we think that each political party has a perfect right to select its candidates as it pleases and have their names printed under its party heading, that there is nothing in law nor in reason preventing two or more political parties selecting the same individuals for one or more of the offices to be filled. So the state Supreme Court understood at the time, at the relevant historical time, that there was no reason to prevent fusion voting. And this goes to Your Honor's question.
Could you, it sounded like that, what you just read, counsel, said that the parties there's no reason why a party should not be able to print its own ballot. That's different from the Australian ballot, isn't it?
No, Your Honor. And this case was decided in 1893. It was decided with respect to the Australian ballot law that was then in effect. And the language, and I apologize if I garbled it, was there's nothing in law nor in reason preventing two or more political parties from selecting.
Go back up a little bit. I thought that there was a phrase before that.
I'll read the whole quote again. We think that each political party has a perfect right to select its candidates as it pleases and have their names printed under its party heading.
Okay.
And I believe that refers to the Australian ballot, right? To have their names printed by the state under its party heading on the Australian ballot.
Now that was before the kind of brouhaha that happened in 1896 with William Jennings Bryan, and you had the populists wanting one vice presidential candidate, and you had the Democrats wanting a different vice presidential candidate, and the chaos that ensued, at least potentially because of that. Do you think that that changes the analysis? that experience?
I don't, Your Honor. I mean, the William Jennings Bryan lost the presidential election. The democratic process functioned. The people spoke. That's how democracy works.
But what if he hadn't? What if instead of William McKinley winning that election, we had William Jennings Bryan winning the election? How do we determine who his vice presidential candidate is?
Your Honor, I don't pretend to be an expert on, the federal constitutional provisions of the selection of the vice president at that time. I'm sure the system would have worked it out, but I don't believe that one election where there was some notion that, there were these multiple vice presidential candidates. I don't believe it was the reason, and the petition expressly alleges that was not the reason that the Kansas legislature outlawed fusion voting in 1901. The petition alleges, and I would remind the court, we're here on a motion to dismiss. The petition alleges that the legislature outlawed fusion voting because it wanted to stifle competition, because the Democrats and the populists had successfully fused in the 1890s, and when the Republicans regained political power, they said no more. We don't want fusion voting. We don't want to face the competition. And this was, not unique to Kansas. It was happening across the country. But that is what, on the procedural posture of this case before this court, was the reason that was adopted, not because of the election of 1896, nor do I believe that the unique circumstances of presidential and vice presidential candidates would justify outlawing fusion voting for all offices in the state of Kansas. This unique circumstance where you have a pairing is very different than I've got a judge who's running for office. I've got a legislature who's running for office. In our case, the plaintiffs who are seeking to run for state legislative seats. What does the election of 1896 say at all about how fusion voting for state legislative offices for our plaintiffs would cause any problems? And I respectfully submit it says nothing about that because the circumstances are not the same.
I'd like to talk a little bit about the claim of voter confusion that results with fusion voting, and in particular with a system where you would have multiple candidates, or you'd have a candidate listed multiple times. So a candidate listed, say, under the Republican Party, and then a candidate listed under the United Kansas Party on a Kansas ballot. If you are in a jurisdiction that requires paper balloting, how is that not confusing?
Well, Your Honor, we have states that allow that, New York and Connecticut.
Sure, but that doesn't mean that states are compelled to. That just means that those states have determined as a policy matter that that's what they're going to do. But what if the Kansas legislature has determined otherwise?
Well, but to Your Honor's question about confusion, I think that the states that allow it provide us the most relevant data points. Is there any evidence of voter confusion there? I'm not aware of it. And if the state is, they are free to bring that in as evidence on remand to establish that voter confusion is a legitimate state interest that's actually furthered.
But just from a rational perspective, I mean, if I go in and I see the same name listed twice, what am I supposed to do? Do I vote for all of the times that name shows up? Do I vote for one? And if I vote for all, does that toss the ballot?
Your Honor, I think you're underestimating the intelligence of Kansas voters, who I think are probably as capable as New York and Connecticut voters to understand how to vote a fusion ballot. Presumably, there would be instructions on the ballot that instruct the voter, choose one. There would be educational campaigns, either by the state and certainly by the political parties, explaining what the ballot is like, and sample ballots printed by the League of Women Voters and other organizations. In the same way a voter understands how to vote on any ballot, they would understand how to vote on this ballot.
But isn't the danger of having a voter misunderstand and thus have that person's vote not be counted a danger that, from a policy matter, the state should be concerned about?
Not if it is not grounded in fact. And this is not a case, Your Honor, where we have the state legislature having conducted hearings and made legislative findings that there's actually any real danger of voter confusion. Even Timmons disclaimed any reliance on voter confusion as a basis for upholding Minnesota's laws in that case. So in my mind, that was one of the district court's weakest arguments, and it did not. Your Honor has done a better job of explicating the concern than the district court did. But I do not see any logical leap from I have a name listed twice in the ballot with one with the Republican Party and one with the United Kansas Party, that is likely or inherently likely to confuse voters any more than any other manner of voting. I see that my time has expired. If I may just take 30 seconds to urge this court to exercise your independent judgment of both the burdens that the anti-fusion laws impose and of the asserted state interests here. And I know when I read the district court opinion, and frankly, when I read Timmons, and I really think about what the court is saying, and I didn't have time to address the details, but there's not much there in terms of the burdens. They're conjectural and hypothetical, and there's no evidence that the harms that they hypothesize have come to pass in New York or Connecticut, and the burdens here are severe, and that they prevent political parties from doing the one thing that they are constituted to do, which is to nominate and elect candidates to get amass political power through popular support at the ballot box. And that is what United Kansas is prevented from doing by the anti-fusion laws.
Thank
I
you.
urge you to reverse the district court and remand. Thank you.
Are there any other questions from the panel? All right, thank you very much. You have 3 minutes for rebuttal, thereabouts, right? Welcome. Counsel, what does this language in section 3 mean?
Your Honor, obviously the Kansas Supreme Court has never interpreted that provision, but I believe we cited, I think it was on page 14 of our brief, the virtually identical language has come up it is included in a number of other state constitutions, and those state Supreme Courts have explicitly rejected the constitutional challenges to fusion voting, just like that we have here under that language. So there's no basis in law to interpret they have no constitutional predicate to say that language is somehow broader than the U.S. Constitution, or that it somehow endows them with a constitutional right to impose fusion voting on the electorate. The reality is that the Kansas Constitution, I'm not aware of any specific provision on that, other than to say that our Supreme Court made clear, I believe it was in the Solomon case, and they had, or the Russell case, I'm sorry, excuse me, and the court reiterated that point in League of Women Voters 2 just a year and a half ago or so, that the first free speech clauses in the Kansas Constitution are to be read coextensively with the U.S. Constitution.
Or I believe the language was they were at least as expansive.
Right, and it's sort of interesting because the language that the Supreme Court had always used was coextensive. Justice Stegall then added at least as broad. So, there's no indication whether he was suggesting that they were then going beyond that, or whether that they were tying it basically to the original coextensive language. And
it's like they were cracking the door open a little.
Yeah, I mean, it's not clear. Of course, I would respectfully submit that any opening of that door would need to come from the Kansas Supreme Court and not from this intermediate court, which is bound by the Supreme Court precedent. But
So we can peek through the door, we just can't push it.
Yeah, I mean, however you want to put it, right? Ultimately, though, I don't think that you need to travel far down that path, because there is the language that the plaintiffs are tying their claim to are found in other state constitutions where state Supreme Courts have interpreted that language and found that language is solid enough to support the state's prohibitions on fusion voting. So I don't think Section 3 gets them anywhere.
I've read those opinions, and what I find a little bit troubling is they just the opinions say, well, it doesn't violate that provision, but it doesn't tell us what the provision means, which is a difficult place for a court to be in if we're supposed to be determining whether that provision is violated. So what does it mean?
Well, I guess, when I look at it and, given that I mean, the short answer is there is no definitive answer. I believe the Kansas Constitution found its origins primarily in the Ohio Constitution. And, there's another state Supreme Court that rejected it on the same language. I don't know, in terms of consulting for the common good, I don't see how that language, there's nothing in that language that to me would impose a burden on the state or restriction on its ability to control the ballot or to because the bottom line here is the statute, what we're dealing with in this prohibition is it's not constraining anyone's speech. It's not constraining anyone's ability to nominate whomever they want. This is simply a ballot manipulation measure. And I know that there's sort of been a lot of discussion.
Just a second.
Yeah, please go ahead.
You can't nominate, as I understand the operation of this law, you can't nominate somebody and have their name appear in two slots on the ballot.
That's correct. But they are
How
able.
is that, that seems to be a prohibition to me.
Well,
You
Judge,
can't do it.
yeah, I guess
No means no.
I would push back on that respectfully because their party is able to nominate whatever individual they want. There is a ballot law. I mean, they are still able to endorse the person. They can support him. They can campaign for him. That individual also can
And
accept their
Name
nomination.
can't be on the ballot.
Well, Judge, the same restriction would apply. I mean, if they want to have unfettered ability, then the same rules would apply. For example, if, the state has restrictions that you have to be, a resident of a certain area, or that, states have had that you have to be registered for, with a particular party, and you have to have been registered for a particular time. I mean, well, all of those restrictions are reasonable rules and constraints that the state is able to put in the law to control ballot access and ballot manipulation. And so, I mean, if they have simply
But
unfettered
from the
access.
standpoint of the candidate who
Sure.
has been nominated by, let's say, two different political parties,
Mhm.
that candidate is left truly with a Hobson's choice, take this horse or none at all. Choose which of these parties you're going to run under. Even if that candidate wants to run under a different one, then chances are United Kansas is not going to be that choice.
The candidate does that. The key is that the candidate has the choice, and there's nothing in.
But is it really a choice?
Well, why wouldn't it? I mean, the candidate can decide to run on whatever he knows what the rules are going into it, and the state has very legitimate interests that we talk about in our brief in terms of why you would have this rule. And so what the candidate makes the decision whether or not to, which party he wants to run on. I mean, he doesn't have a right to run on multiple parties, but it ultimately is up to that candidate.
And what is the effect then if the candidate determines that that person will run as a Republican or a Democrat rather than United Kansas? What is the effect on United Kansas's ability to assemble?
Well, they can still do. I mean, they have virtually unfettered ability to do whatever they want, other than to have that candidate's name appear with their own name. I mean, it's their whole MO is to say we're only going to select the individual who has been nominated by a different political party, but they're still able to do any other action to support that candidate. They can, as I said, they can endorse him, they can fund him, they can announce that he is their candidate of choice. I mean, the ballot itself is not a billboard. The ballot itself is simply, this is a state-controlled, state-governed access. I mean, if anything, the ballot itself is government speech, and so and it's in a non-public forum at that. So I mean, there's no constraint.
But even that, I mean, it strikes me that we've been, I think, rightly staying away from the policy question, which is for the legislature to determine. But Anderson verdict itself, the test that the federal courts have applied here, wades into the weeds in determining whether those goals that were set to be achieved when the legislature adopted this, or just in the broad sense, are actually achieved here.
Well, I guess what I would say at the outset, and I think it's very important because it didn't get covered in my friend's argument is I don't think you can understate the importance, even if we end up going to Article Anderson-Burdick, because I don't think we need to get there, is the importance of Article 4, Section 1, which I think grants explicitly in our Constitution broad discretion to the legislature to determine the mode of voting. I think it was Judge Hill who asked if the Constitution is the same now as it was in 1861. I mean, the voters, the electorate adopted that constitutional amendment. I believe it was in 1970. And it could have been 1974, but right around that time. So that was a constitutional express delegation, broad delegation of authority to the legislature to determine the mode of voting, which is why the policy argument here is so important. That ultimately is what this is. I mean, to whatever extent they want to talk about the motivation of people back in the late 1800s. And I think, by the way, it's not just William Jennings Bryan. I mean, you have the whole legislative wars that we had here in Kansas, where there were Gatling guns on the, across the street as to who's in power. So I think that's important to point. But the reality is that whatever all of that history aside, the legislature and the electorate, through the adoption of that constitutional amendment in 1970, expressly put into the language that the legislature alone gets to decide what the mode of voting is going to be. And I think the Kansas Supreme Court, in the League of Women Voters II case a year and a half ago, further solidified just how broad of a delegation of authority that is. So, I mean, ultimately, there may be virtues and whatever policy arguments the other side wants to tout in terms of why they think that it's beneficial to have fusion voting, to allow it. But that is a decision for the legislature and not for any political party. I mean, I'll also point out, in our Constitution, in contrast to certainly a Kansas Constitution, but we don't have political parties mentioned in our Constitution. I mean, it all focuses on individuals and voters, but you contrast it to, say, Germany, where you have, when they have forceful, their own constitutions heighten the power of political parties, where then, there sort of is a bleeding over in terms of the power that the party has both in legislative and executive functions. And once that party goes out of power, then in their sort of their parliamentary system, then the executive branch has to go away too. We don't have anything like that in the United States, and we certainly don't have it in Kansas either. So I think that there is a primacy of political party power that they're advocating that I just don't think exists in our system. So
I ask your opponent, and I'll ask you directly, is this a justiciable issue?
I would say the answer is no, Your Honor. I think that
Tell me why.
okay, I think that Article 4, Section 1 dictates that the legislature has the authority to determine the mode of voting. And I suppose there are
Subject to
constraints on equal protection and due process, at least as articulated in the League of Women Voters case. But the standards that they adopted were extremely broad, anything reasonable. I mean, if you look at the language that they utilized in that decision. So how do you then, as judges, decide what is reasonable? Now, of course, there's sometimes when you're like, look, that's what we do as judges, right? We decide what is reasonable. But in terms of their motivation, because they have argued that this is a system that would create more yield more so-called moderate candidates. They feel that the legislature and perhaps the general public is too balkanized right now. I mean, I can't think of anything more dangerous for the court to be deciding that the public or the legislature is too polarized and that we need to have more, so-called moderate candidates. I mean, as I said in our brief, that's sort of like beauty. I mean, it's in the eyes of the beholder. Some might argue that the legislature is more representative than ever, given that we have super majorities of one party right now.
Would we have to find fusion voting unreasonable to overturn this decision?
Yes, I think that is part of, I mean, given what the test for equal protection and due process, I mean, that's part of what you'd have to do is to say that this is, that it
There are other
is.
things would have to do.
Sure, yeah, of course.
Primarily, we'd have to say, this is unreasonable.
The prohibition is unreasonable. Yes. I mean, that's one of the kind of threshold decisions that you'd have to make. And there's no basis in this. I mean, again, this is an issue that they're free to take this across the street and they can argue to the legislators that we think this would be a better system, just like they could about ranked choice voting or any other mechanism about methodology for electing our candidates. But
That's also why we have a constitution to set a floor for some things where you say at some point, and the legislature can take lots of actions, whether people agree with them or not. But at some point, there is a line that cannot be crossed. And so I think that's the question that's presented here.
yes,
Have we,
I would
have
agree
we
with that.
butted against that line?
Yeah, I would agree with that, Your Honor. I mean, I think when you look at the precedent, again, under the court has, I mean, they originally had an equal protection claim and they abandoned that claim here on appeal. But, given the coextensive language and given the fact that we've had basically an unbroken line of cases for 125 years, including a U.S. Supreme Court decision, which I acknowledge is not definitively binding on this court, although, if the provisions are to be read coextensively and whatever crack of the door, that there may be, I mean, that's a pretty good indication of where the court should be. And in general, I mean, just as they did on equal protection, what the court wrote by an opinion by Justice Stegall in the Rivera v. Schwab case, that, like on equal protection, we look at Supreme Court precedent. That is what governs this. And in the free speech context, given that they have said that it is to be read coextensively as well, I would respectfully suggest that the same principle would apply and that the Supreme Court decisions should be looked to for, if not absolute guidance, pretty clear guidance to this court in terms of how the plaintiff's claim should be evaluated.
Counsel, let's say that we disagree with you with regard to Section 3. That Section 3, which has not been construed by our Kansas Supreme Court, that Section 3, that language means something. It's different. And so we determine that it provides broader protection in some way. In that instance, we have a clash between an assembly right, potentially, and then this articulation in Section 4 about the legislature determining the mode of elections. So we have a constitutional clash between two provisions. What is the test that courts use to resolve those questions?
Well, Article 4, the Supreme Court held in League of Women Voters 2 and sort of invoked the canon of construction that the more specific governs over the more general. And so, you do have in Article 4, Section 1, a very explicit sort of directly on point statement that in terms of dictating what the mode of voting will be, that is a legislative determination and an exclusive legislative determination. So when you're looking at sort of the conflict there, I mean, and of course, Article 4, Section 1 was adopted many years after the Article 3 of the Bill of Rights. So, I mean, I think that is also important. And, in terms of looking at any conflict, the fact that we have had this statute in place for 125 years and it went unchallenged. Now, that's not dispositive and we don't suggest as much.
I suppose that maybe I articulate, like I understand your arguments as to why these laws wouldn't violate Section 3, right? But my question is a little bit different. It is, when we are trying to make that determination, what is our test? It would seem that a reasonableness test that was articulated with regard to Section 4 previously ignores the importance of a right in Section 3. And so
Well,
what it,
except that the
on
court
the
did
other
come-
hand,
Right.
as strict scrutiny, if we were to look at strict scrutiny, I think that would read out the importance of Section 4. So where does that leave us?
Well, remember that what they did in League of Women Voters in interpreting the scope of Article 3 of Section 3 of the Bill of Rights. I keep getting articles and sections confused. I'm sorry.
It's unfortunate that we have
Right.
different.
I know but they did in construing that adopt a very deferential standard towards the legislature. They could have adopted something that had a lot more teeth, if you will, in it, but instead they suggested, that anything reasonable, in terms of, in that case, it dealt with signature verification, but it was reasonably uniform. It wasn't anything, in fact, they explicitly rejected a strict scrutiny standard in that case. The same thing with due process. It was, a reasonable opportunity at a reasonable time, anything meaningful. It was a very flexible and deferential standard that the court was adopting. And I think they did so in recognition of the broad flexibility to which the legislature is entitled by virtue of Article 4, Section 1. So, they could have come back and, that's what the plaintiffs had argued in that case. They wanted strict scrutiny, and the majority explicitly rejected that position in favor of a much looser standard that gave the legislature the latitude it needs. And in particularly in this area, there will always be disputes, right? This is when we're dealing with election regulations and, everything by its very nature is going to impact the right to vote, for example. That's why the Supreme Court has adopted in cases like Monroe v. Socialist Workers Party, and to go to Judge Hill's question, and I think it was Judge Hill, maybe it was you, where the court said, look, we don't want
We
to
look
get,
similar.
we're not going to get into a debate about, dueling political scientists and dueling historians as to what is confusing or not. There needs to be sort of legislative facts. I cited a wonderful opinion by Judge Easterbrook in the briefs on that point. And I think that's sort of where the legislature is entitled to that difference, because this is an area where it has the expertise and not the court in determining what the right policy is.
It seems like, and I understand that we're over time, but I'll give your
Sure, no,
opposing
please,
counsel
yeah.
some additional time as well. It seems like this Supreme Court, the U.S. Supreme Court, and during the course of Anderson and Burdick and adopting that test, has forged something different, recognizing this tension between, on the one hand, state election law and the need to have order with regard to state elections, and on the other hand, freedom of assembly and freedom of expression. And so I think that's why we have this sliding scale balancing test that the United States Supreme Court uses just for election laws. Do you think that test makes sense? We're not bound by that text in the Section 3 is.
Yeah, I think it's a great question, and let me answer it in a couple of ways. Number one, the Anderson-Burdick test has been subject to a lot of judicial criticism, that when we're dealing with this balancing test that I think that Judge Easterbrook described it as does it kind of boil down to the judge's priors, and sort of their views of the world. And when there's a concern about the lack of predictability. I think, and what we argued below is that we don't need to go to Anderson-Burdick, that it's a much more direct route through the Article 4, Section 1, just the reasonableness. So I don't think we need to get to the balancing and that test, that's our fallback argument, that you would go to a balancing test like that. But our primary argument is it's just a general reasonableness test, and that comes from the language in League of Women Voters in Article 4, Section 1. The other thing that I would point out is that, that the Supreme Court has said even on this issue, and cases like Crawford, is that when you have something that does not create a severe burden on the party, and we respectfully submit that on the plaintiff, we respectfully submit that that's the case here, that at that point, it really is nothing more than, akin to a rational basis test anyway. So that we're really not conducting the balancing at that point. We're simply saying, that this is, it is like what we would do with a traditional, reason, traditional test. And as a result of that, you don't really even need to get deep into the balancing test.
Other questions from the panel? Would you like to wrap up?
Your Honors, first of all, thank you for accommodating my vacation schedule.
I hope it was great.
It was wonderful, and
Okay,
I
good.
appreciate you moving this hearing. That was greatly appreciated. But I would just say, this is a classic public policy argument. The plaintiffs have raised, and frankly, if you look at their response to the amicus brief from the Honest Election Project, I think that really kind of underscores. They have a lot of policy arguments, and there may be wisdom to it, there may not be. But those are legislative determinations, and that is not the role of the judiciary to decide. We think
So
that
to
this,
answer my first question.
Yeah.
You think the proper forum is across the street?
Yes, Your Honor.
Across 10th Avenue?
that's exactly
That
right.
domed building.
That's exactly right, Your Honor. Yeah, they've directed their attack at the wrong branch of government. They need to go to a coordinate branch. So we'd ask that you affirm the lower court. Thank you very much.
Thank you, Counsel. Counsel, you have 3 minutes and change. So welcome back.
Thank you, Your Honor. I appreciate that. I'll try to not speak too fast. I got a number of points I wanted to get in. I wanted to point out fusion voting in New York was not a policy choice. That was a decision by the court there that the prohibitions on fusion voting were unconstitutional under that state's constitution. You would not be alone in determining that under the Kansas Constitution. Your Honor's question earlier about overvoting, if a voter checked both boxes, my colleague has informed me that at least in New York, that vote counts, and there's no reason it couldn't count here either. You can't aggregate it to one or the other parties, but the vote counts for the candidate for whom it was cast. You spent some time with my friend on the other side talking about League of Women Voters, and I wanted to address that. I think that the state reads way too much into that case and reads it incorrectly. League of Women Voters found reasonableness to be the test under Article 5 of the Constitution, but then it expressly said that the legislature must still comply with other constitutional guarantees. It then remanded the case for consideration of whether the statute there at issue complied with equal protection and due process. And it makes no sense to say it just remanded it to apply a reasonableness standard because it had already applied that standard. It remanded it to apply the applicable legal standard, and it was not a watered down standard. Footnote 4 in our reply brief cites some cases from 2007, 2008, long before the League of Women Voters case, describing the due process test as due process requiring timely and reasonable notice and an opportunity to be heard, describing equal protection as that classification must be reasonable, not arbitrary. Those were the substantive legal standards that already existed in the equal protection and due process case law of this state. It was not a watered down version, a special version of Bill of Rights protections in the elections context. And frankly, reaching that decision would be inconsistent with the other holding in League of Women Voters that the Kansas Constitution is at a minimum coextensive with the First Amendment in its protection of expression and association, because you would be watering it down even below what the First Amendment requires. Most fundamentally, Your Honors, I think this case boils down to understanding what the real burdens are here, and they are severe. They prevent United Kansas from having its preferred nominee appear on the ballot under the United Kansas ballot line. It prevents the party's supporters from being able to vote for their preferred nominee and associate with the political party they wish to associate with, as opposed to with a different political party. And, my friend referenced German law and the political priorities for parties there. We are not seeking that. And we acknowledge that political parties aren't referenced in the Kansas Constitution, but they are referenced in Kansas election law, which requires a candidate's political party affiliation to be printed on the ballot, which is a recognition of the importance and the sui generis nature of political affiliation. And it is that our clients are being deprived of, the ability to have that association at the most important moment when a voter casts their ballot, but also for the months before that, because operation of Kansas law will abrogate United Kansas's nominations as of June 1st. That entire election cycle, those candidates that United Kansas wants to be their nominee cannot be their nominees, are not their nominees. That associational harm extends far beyond and before Election Day. That's something the district court didn't address, although it was briefed below, and it's something that Timmons did not address either. These kinds of cases are decided on a factual record. Timmons was decided on summary judgment. In the Supreme Court, there cites declarations in the record for historical fact. California Democratic Party versus Jones, which we cite for the fact that other avenues of expressive freedom are irrelevant to ascertaining the real burden. Jones decided on a factual record. The Supreme Court cites expert testimony in its own decision. Shrink Missouri PAC versus Nixon, another Supreme Court set case that says we never rely on mere conjecture. The court upheld a restriction there on campaign expenditures, but it did so citing evidence that the state had submitted in the record for how the law there at issue actually advanced the asserted state interest. The parties here, the plaintiffs here, deserve the same opportunity. We urge you to remand this case for development of a factual record while articulating that heightened scrutiny applies given the substantial burdens the anti-fusion laws impose on our parties. Thank you.
Thank you very much. Any other questions? Thank you. I want to thank all of the parties who have submitted their briefs and argued here today, and the amicus who have submitted their briefs. This is an important question, and we will be issuing a written opinion as soon as we're able. And at this point, the court is adjourned.